Dear students, today we shall take up for discussion a lesson on Hart's concept of law. Professor H.L.A. Hart, in his concept of law, has tried to reconcile the conflict between the theories of Austin and Kelsen that emphasize imperative authority as the essential element of a legal norm, and the theories of Savigny and Ehrlich that emphasize social acceptance as essential characteristic of law. Hart has revived interest in analytical positivism in 20th century. In his The Concept of Law, has expounded his legal theory as a system of rules by exploring the relation between law and society. Hart differs from his analytical predecessors by clearly stating that his main objective has been to further the understanding of law, coercion and morality as different but related social phenomena. Hart's concept of law emerged as a substitute to Austin's theory. Hart has dealt exhaustively with the problems faced by Austin. Hart's theory of law is entirely different from the orthodox analytical positivism of Austin, and his views in regard to nature of law is different, having moral and social implications. That is why Hart is styled as naturalist among positivists. In his inaugural lecture, published as Definition and Theory in Jurisprudence, he observed that the questions such as what is a state, what is law, what is right have great ambiguity. He believed that a fruitful approach would be to elucidate the conditions to which true statements are made in legal contexts about state, law, rights, etc. This project was pursued in his The Concept of Law. There is no definition of law or of a legal system as such in the concept. The aim is elucidation. Elucidation of concepts like rule and obligation, which have puzzled generations of legal thinkers. For Hart, we cannot properly understand law unless we understand the conceptual context in which it emerges and develops. Hart's concept of law was an outcome of his comments on Austin's theory. He said Austin wanted to give a precise definition of law, that is why he failed. His view is that any attempt to give a definition of law is bound to fail. Therefore, he suggested the method of elucidation. Hart objected to Austin's command theory on the ground that it failed to encompass the variety of laws. The definition of law as a rule of conduct backed by a threat of sanction may be true of criminal law, but not of civil laws, which mold many legal relations between individuals, such as contracts, wills, marriages. Punitive sanction cannot be said to be of essence of law in modern days. Hart believed the basis of legal norms to be social acceptance. Hart rejects the trilogy of command, sanction and sovereign, which Austin describes as key to the science of jurisprudence. For Hart, the legal system is a system of social rules. In every society, there are social rules. The rules are social in two senses. First, in that they regulate the conduct of members of societies. Secondly, in that they derive from human social practices. They are not the only social rules. There are, for example, rules of morality. Like rules of morality, laws are concerned with obligations. They make certain conduct obligatory. But unlike rules of morality, legal rules have systemic quality. There is a mechanism for making alteration and enforcement of legal rules. There is no such system in case of moral rules. Legal rules are of two types, called by Hart as primary rules and secondary rules. There is an interrelationship between these two types of legal rules. All societies have social rules. These include rules which are optional, such as rules of games, sports, clubs, etc., as well as obligation rules which impose duties or obligations. Obligation rules may be divided into moral rules and legal rules. Legal rules are divisible into primary rules and secondary rules. Primary rules are duty imposing rules and secondary rules are power conferring rules. Hart's analysis of the term rule. Natural law theories look upon law as consisting of rules dictated by reason, positivists as rules decreed by the sovereign, and realists as rules applied by courts. However, none of these theories provides us with an adequate analysis of the term rule or the notion of a system of rules. Rules are concerned not with what happens, but with what ought to be done. They are imperative and prescriptive rather than indicative and descriptive. In some cases, rules may be constitutive and they will define the activity in question. For example, rules for playing of bridge, football, tennis, etc. In others, they regulate activities which activities would in any way take place whether there were rules or not. For example, rules of grammar, spelling, etiquette, law, etc. Rules involve two aspects: external behavior such as, for example, stopping at a traffic signal, and internal attitude that such a behavior is obligatory. But in order to ascertain whether a person accepts the existence of a rule, we must look not to the inner workings of his mind, but to what he says and what he acts. Here there is a better explanation of compliance with law than that of Austin. Compliance arises not out of coercive process, but out of a sense of obligation. And this is shown by the fact that even a person who cannot be compelled to obey the law is still considered as having an obligation to obey. Law and rules are concerned with obligation rather than coercion. Coming now to the legal rules, we find that in some respects they are analogous to the rules of games, clubs, etc. But again, moral and legal rules have also something in common. Both legal and moral rules are not optional. Rules of games may apply to players and that also during the time of the play, but not so the legal or moral rules. Morality may apply to every human act, while law, though narrower in its scope, extends to a number of such acts. Secondly, games and clubs are not compulsory. Withdrawal and resignation are permanent possibilities. There is no such choice in the case of legal and moral rules. Law applies to a citizen whether he likes it or not. Of course, one may withdraw from a particular legal system, and this involves immigration from a state. But even so, avoidance of legal systems altogether is not possible. Hart's analysis of the term rule, explaining the internal and external aspects of rule observance, is really valuable. Primary rules. Hart asked us to imagine a community in which only primary rules exist without a legislature, courts, or officials of any kind. Such a group lived in a pre-legal state. Hart says such a primitive small community is closely knit by ties of kinship, common sentiment, and belief, and placed in a stable environment. They could live successfully by such a regime of unofficial rules. According to Hart, primary rules are those that impose duty upon individuals and are binding because of social acceptance. In primitive community, there were only primary rules which imposed duties or obligations on individuals. Such a community suffers from three defects because of social control based on a regime of unofficial primary rules. The three defects are: number one, uncertainty. The first defect in the simple social structure of primary rules is uncertainty. In such a community, there is no systematic procedure to identify as to what the rules are or what their scope is. There is no definitive test to distinguish legal rules from other social rules. Second defect is stationary. The second defect is the static character. There is no instrument or authority in such a society for deliberately adopting the rules or introducing new rules, and no way to modify the primary rules. Change is accomplished only by the slow process of growth and decay. The third defect of the regime of primary rules is the inefficiency. There is no agency for determining the rule violations and for settlement of disputes. The rules are applied only by diffuse social pressure. Secondary rules. According to Hart, secondary rules are power conferring rules, such as the laws that facilitate the making of contracts, wills, trusts, marriage, etc., or which lay down rules governing the composition and powers of courts, legislatures, and other official bodies. These rules are secondary to primary rules. According to Hart, there are three kinds of secondary rules. Hart says the remedy for the three defects of the regime of primary rules is the supplementation of primary rules with secondary rules. The introduction of secondary rules is a step from the pre-legal state to legal state. The three defects were removed by the introduction of three types of secondary rules. They are rules of recognition, rules of change, and rules of adjudication. Rule of recognition. The remedy for uncertainty of the regime of primary rules is the introduction of rule of recognition. The rule of recognition authoritatively settles the doubts as to what the rules are and what their scope is. It provides criteria for how legal rules are to be identified, to be followed and enforced within the community. Rules of change. The remedy for static character of primary rules is the introduction of rules of change. These rules regulate the process of change by conferring the power to enact legislation in accordance with specified procedures. These rules also confer power on ordinary individuals to produce changes in the legal relationships they have with others. Rules of adjudication. The remedy for inefficiency of the regime of primary rules is the introduction of the rules of adjudication. These rules confer competence on officials to pass judgment in cases of alleged wrongs and also to enforce the law. These rules provide a mechanism for effective adjudication of rule violations. These secondary rules relate in various ways to the primary rules. The rule of recognition lays down criteria for identifying the primary rules. The rules of change provide mechanism for changing primary rules. Rules of adjudication specify for determinations whether primary rules have been violated. Hart remarks, in a developed legal system, law is a union of primary and secondary rules. Rule of recognition. Hart's view is that a legal system arises from the combination of primary and secondary rules. Primary rules are those which simply impose duties. Secondary rules are power conferring rules. Of secondary rules, the most important are those which confer power to make and unmake other rules in the system. In other words, rules that determine the criteria which govern the validity of the rules of the system. Hart called them as rules of recognition. These are rules of a higher order, being rules about the other rules of the legal system. They can be looked at from two different angles. We may regard them as prescribing the method and procedures for creating, annulling, and altering rules of law, or we may look on them as tests to discover whether a given rule is one of the legal system in question. The English rule about parliamentary sovereignty at one and the same time lays down the procedure for legislation and serves as one means of identifying rules as rules of English law. It is these rules of recognition which, in Hart's view, transform a static set of unrelated rules into a unified, dynamic legal system capable of adoption to social change. He parts company from Kelsen. however, in refusing to regard them as hypotheses. The basic rule of a legal system is not something which we have to assume or postulate. On the contrary, it is itself a rule accepted and observed in the society in question. Unlike the other rules of the system, it cannot of course be derived from any more basic rule. It is nonetheless a rule, a customary rule, acceptance and observance of which finds expression in social practice and the general attitude of society. Although the rule about parliamentary sovereignty in England cannot be derived from any other rule of English law, it is more than a hypothesis. It is a customary rule of English law, followed in practice and regarded as a standard requiring compliance. Certainly, the basic secondary rules concerning the criteria for identification provide unifying force to a legal system, but are there not other factors of equal importance? Suppose, for example, that the legislative sovereign is forcibly replaced by a new body, but that law remains in every other respect unaltered, and that the various rules in the different branches of private and public law retain their validity. Hart's analysis would suggest that in such a case, the legal system must be said to have changed. But it might equally well be argued that what was changed is not the legal system, but only the basic constitution of the state. Well-developed legal systems, such as English law, contain both primary rules and secondary rules in Hart's sense. International law is a less developed system which lacks the basic rules relating to the criteria for identification. Therefore, it qualifies in Hart's view as a mere set of primary rules. According to Hart, the rule of recognition is essential to the existence of a legal system. It determines the criteria by which the validity of the rules of a legal system is decided. He claims that for every developed legal system, there is an ultimate rule of recognition, whose validity cannot be questioned and whose existence depends solely on the fact that it is accepted by officials from the point of view. Hart says, in order to identify the rule of recognition in a particular legal system, one has to see how the officials, judges, legislators and other public functionaries work and behave. He says, in the United Kingdom, the rule of recognition is what the Queen in Parliament enacts is law. Where there is a written constitution, the provisions of the constitution are the rules of recognition. Validity of the rule of recognition cannot be questioned. It is neither be valid nor invalid, but is simply accepted as appropriate for use in this way. Hart's view on judicial function. In developing his theory of a legal system as a union of primary and secondary rules, Hart seeks to reject both the strictly formalist view with its emphasis on judicial precedent and codification and the rule skepticism of the American realist movement. In so doing, he strikes something of a compromise between these two extremes. He accepts that laws are indeed rules, but he recognizes that in arriving at decisions, judges have a fairly wide discretion, and he is in any event driven to this conclusion by virtue of the rule of recognition. If there is some acid test by which judges are able to decide what are the valid legal rules, then where there is no applicable legal rules or the rule or rules are uncertain or ambiguous, the judge must have a strong discretion to fill in the gaps in such hard cases. Hart recognizes that as a consequence of the inherent ambiguity of language, rules have an open texture and are in some cases vague. He accepts the proposition that in hard cases, judges make law. The relationship between law and language pervades much of his thinking about law. He argues, for instance, that language has an open texture. Words have a number of clear meanings, but there are always several penumbral cases where it is uncertain that rules can provide predetermined answers to every case that may arise. This does not mean, however, that the meaning of words is completely arbitrary and unpredictable. In most cases, judges have little difficulty in simply applying the appropriate rule without any need to call in aid moral or political considerations. Hart's view on law and morality. Unlike Kelsen and Austin, Hart's positivism contains within it the content of natural law. His greatest contribution lies in his attempt to build explicitly the concept of natural law within positivism. He concedes that there is a core of good sense in the doctrine of natural law and argues for what he calls a simple version of natural law. According to Hart, natural law doctrine contains certain elementary truths of importance for understanding of both morality and law. Hart makes an attempt to bring out certain facts, what he calls natural facts, which are also common characteristics of both law and morals. Though it is not logically necessary for law or morality to have a certain content, according to Hart, there are compelling reasons for it to do so. These reasons have to do with certain natural facts and aims of being constituted as men are, and these facts and aims form a setting in which a certain content of natural law is a natural necessity. Professor Hart expounds certain generalizations, indeed truism concerning human nature and the world in which men live, show that as long as these hold good, there are certain rules of conduct which any organization must contain if it is to be viable. Such rules do in fact constitute a common element in the law and conventional morality of all societies, which have professed to the point where these are distinguished as different forms of control. Such universally recognized principles of conduct, which have a base in elementary truths concerning human beings, their natural environment, and aims, may be considered the minimum content of natural law. Minimum content of natural law shared by both law and morality. Hart is of the view that there is close connection between certain natural facts and legal or moral rules, inasmuch as both legal and moral rules pursue commonly and consciously such natural facts, which natural law takes its starting points. These natural facts are: first, human vulnerability, the natural fact that human beings are vulnerable to bodily attack. Second, approximate equality, that men are approximately equal in strength, ability, and intelligence, so that there can be no natural domination and cooperation becomes necessary. Third, limited altruism, that human beings are neither predominantly selfish nor predominantly altruistic, but rather a bit of each. 4. Limited resources, that the resources of the each are limited and scarce, hence making the institution of property necessary, not necessarily individual property. And fifth one, limited understanding and strength of will, the need of rules to make people to respect persons, property, and promises, and the need of sanction. These natural aims are minimal, the desire for survival and the desire for social life. Given these facts and aims, according to Hart, the law as well as morality must have certain content, but the necessity of this content is natural and not logical. It has only to do with there being good reasons for law and morality to have this content, and nothing at all to do what the law is in any legal system. Hart is of the view that there are no logical connections between law and morals, and that there are no moral criteria for the validity of law. Yet he concedes there is a distinction between order and good order, good order implying justice, morality, and fair-mindedness. Moreover, law as a social rule, like a rule of morality, must contain a certain content of natural law. The law, therefore, has to be compatible with it. However, the connection between law and natural law is not logical, but the former is perfectly valid even though it is incompatible with natural law. In short, law is law even though it fails to satisfy moral test. This lesson is an attempt to elucidate Hart's concept of law. Thank you.